button and let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. What just flew into my eye right as I pressed the button? Goodness. It's like every time. All right. So, hello, my friends. Now, are we here kicking off the tubes connected? It's a Monday, as you can see. And let's get this screen F11'd up. Before we get started, put the phone over there. All right, let's roll. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Donald Trump being disqualified already. That's right, my friends. Apparently, election's over. We have a couple of knuckleheads over on MSNBC. They've done some constitutional analysis. One of them used to be a judge. You remember him from the January 6th so-called fake select committee. This guy, Judge Luttig, well, they've done some deep analysis over there, him and some other smooth brain, and they've come to the conclusion, it's game over, nothing else to really talk about here. So we'll go through this story. It's a lot of fun. Adam Schiff says if you attack our elections, then yeah, you should be disqualified. And this is a theory now that is seeing mass adoption. So we've been talking about this theory for a while. How is it going to come into fruition? Here it is. We've got Asa Hutchinson, who's apparently running for president, who has said that, yeah, Trump might already be disqualified, kind of gobbling up this new theory. And we even have a senator saying basically the same thing. Look, the Trump prosecutions are disqualifying and he should just drop out. So we'll get to that in our third and final segment. We'll start the show off today by going through this motion, which is a nice motion here from Mark Meadows. Now, his legal team is not playing around, all right? They filed another motion, that we read last week, where they were saying, do not even think about delaying our hearing because another person wanted to request a postponement to consolidate the federal question about whether this case is going to be removed from the state court up into the federal district court. And Meadows, on top of that, filed a motion to dismiss, saying, look, I got federal immunity, supremacy clause, this whole thing is nonsense. Dismiss me, Judge. So it is a doozy. It's about 34 pages. We'll go through the full thing. There's more news out about Meadows saying that if he, as the chief of staff, got an order to declassify something, well, then he would know about that, right? And so maybe he can be the star witness on the January 6th case to determine whether or not those documents were ultimately declassified. And Pence isn't sure about that. So we've got kind of two different pools of water we got our feet in here today. We've got the January 6th case and the Florida case talking about some of the classified documents. Pence, not so sure about the declassification. Now, Pence has to be very careful about this case because he's got his own classified documents problem himself. So he's a lot more vocal when he's talking about the January 6th cases, but then is suddenly a little quiet when it is my classified documents problems. So we'll go through all of that. And then there was a doozy, a couple articles came out over the weekend about Hunter Biden's lawyers and basically bullying the DOJ. I'm like, gosh, man, what incredible. Man, I could be like an invincible defense attorney if I could practice this way and like threaten the president. It's amazing. It's like, hey, we're going to subpoena the president and he's going to have to come in here. It's like, gosh, talk about leverage from a criminal defense perspective. And these guys were executing it full out. So Politico, apparently, Hunter's lawyers are like, they're playing hardball, man. They leaked stuff out to the media showing what an absolute joke this entire exchange was. During plea negotiations, Hunter's lawyers were threatening to subpoena Joe Biden, saying, hey, we're going to drag his butt in here. And of course, the DOJ doesn't want to do that. They don't want to implicate their guy. They're concerned about constitutional implications when it's their team, but not so much when it's the other team. When it's Trump, they just go raid the residence and rummage around through Melania's underwear. We've also got reaction to this. So Tristan Levitt, he is one of the attorneys and from the organizations representing the whistleblowers, Gary Shapley and others. And so he put together a very nice response thread, very, very detailed. We'll hit a little bit of it. We've got reaction from Joe Biden, which is not really much reaction about what you'd expect. And then we got a clip from James Comer saying, doesn't all this kind of amount to obstruction? Isn't that what we're seeing here? If the DOJ is not going to do their actual job, in fact, if we're going to have them almost collude to trip themselves up, what do we do if they're obstructing themselves, in other words? So we'll get into it. As you can see, there is a lot to unpack today, my friends. I'm so grateful that you are here. I hope you had an incredible weekend. We had a lot of fun this weekend. We did a members-only interview with my friend Sanjeev Javia. A lot of fun. We talked about 2.5 hours about health and wellness and food nutrition, and we had a testosterone question in there. A lot of fun. So we checked that out. Watchingthewatchers.locals.com was where you can join our community to do that. We also, if you want to catch that, we also have our movie night date now scheduled for our members only, whether you're a member on YouTube or Locals. 9/2 is the day, September 2nd, 2023. The movie to watch is going to be V for Vendetta, so we'll all watch that on our own time, and then reconvene 6 o'clock Eastern, September 2nd for our members only movie night, baby. That's Wims' birthday. Amazing. So, hey, another Virgo in the house. Mine's right after that. So, amazing. So, we're going to get into all of that. If you want to join us either as a member on YouTube or join us at watchingthewatchers.locals.com. We do member-only streams in the morning. We had a lot of fun this morning talking about Joe Biden taking a quick trip over to Maui down there, and a lot of other fun stuff. So check us out, watchingthewatchers.locals.com. We also have our brand new website where you can sign up for our daily newsletter. So if you miss anything in the show, you'll get a daily show report delivered to your inbox every day after the show. So you can see exactly what's going on. Also, robertgovea.com has the reports. So if you can't watch a full segment, you can read a summation of exactly what we're talking about here as we go through the news throughout the day and the week. Now, before we get into it, let's make sure that we're healthy and we're properly fortified and nutrified, courtesy of our friends at fieldofgreens.com, because we all would like to lose those leftover pandemic pounds, wouldn't we? But how sick are you of all the ads for weight loss pills and fad diets? You know, we've all been there. We've all done that, and they just don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, and the weight would probably fall right off. But look, vegetables, not a fan, and fruit, who's got time to prepare that every day? I don't. Instead, let's talk about Field of Greens, baby. Field of Greens is a science-backed formula of very specific fruits and vegetables that you're not going to find in any other product. We know that proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look healthier and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, woo, you've lost weight. Whatever you're doing, keep it up. So let's get you started. Head on over to fieldofgreens.com. Don't forget to use code Robert when you check out. And you're going to see when you go over there, Field of Greens, it's not just greens, it's all sorts of other stuff for weight, for sleep, for movement, joints, a lot of good stuff. Real products, real ingredients. Check them out. Fieldofgreens.com with promo code Robert to check out. Save 15% off. All right. Now let's get into it because we've got some motions to dismiss. Donald Trump's former chief of staff when he was president, Mark Meadows, files a motion to dismiss. And of course, we love ourselves a good motion to dismiss here. So we're going to unpack it in detail, go through the full filing because it has pretty serious implications. This is in the case of Big Fani versus Donald Trump. It's taking place out of Georgia, and it's a racketeering case. And there's 18 other co-defendants aside from Donald Trump and from Mark Meadows. So Meadows is one of many people who are caught up in this big, overbroad prosecution from the Georgia DA. And he's now saying, I am immune from all of this. I was a federal officer. This is a state case that should have been brought in federal court. It is not. And the federal supremacy clause means that I am immune. So we're going to go through that. We've also got some other stories about Mark Meadows because he's kind of a key witness in another case, which might be the classified documents case. And we'll check in on that with some reaction from Mike Pence and the update on the story. But the motion you see here, Mark Meadows, state of Georgia versus Mark Meadows as the defendant. And he's writing this on behalf of himself. He's one of 18 others. Donald Trump is another one. And it's the state of Georgia versus Mark Meadows. But notice that we're not in state court. We're actually in federal court. the United States District Court for the Northern District of Georgia. Meadows is trying to remove this. He's saying Fani doesn't have jurisdiction. She's bringing basically a federal case in state court. Can't do that. 34 pages. We'll hit the highlights. They filed a correction, but this is the memo in support of the motion to dismiss. And so they write the generic motion. Here we're filing this motion, and they back it up with a memo. We'll fast forward through the table of contents. You'll see it's not long, couple parts with a couple of highlights. Table of cases referencing the various authorities that they use to support their claims, including case law and other legal opinions, memos from congressional committees, and so on. Different rules, federal rules of criminal procedure, and of course, the United States Constitution. Always a nice one. We'll see if they care about it. So this is what it says. All right, Your Honor, federal judge, federal court. Defendant Mark Meadows, Trump's former chief of staff, moves to dismiss the indictment against him under the rules. As a federal official at the time of the charged conduct, he is immune from state prosecution under the Supremacy Clause of our U.S. Constitution. And so remember, Donald Trump, in all likelihood, is going to be able to claim each one of these same type of protections. And so these arguments are almost just like a trial run right now to see what this judge does with this. And he'll file it. You would expect to see something very similar to this filed by others, or very similar to get to this same point. Okay, if Meadows is now asking for a removal and a dismissal back to back. We haven't even waited for removal yet. That's how aggressive he's being, right? We're going very, very quickly here. But you would expect similar arguments to be made by other defendants. And if the entire case gets removed, then they'll all be in federal district court rather than Fani's state court. They continue. Big Fani's prosecution of Mark Meadows threatens the important federal interest in providing the President of the United States with close, confidential assistance firmly entrenched in federal law for nearly 100 years. Referencing Elena Kagan, who's a current Supreme Court judge. She wrote that in a law review article. Oh, we love that. And gives rise to precisely the sort of state interference in federal affairs the Supremacy Clause prohibits. Saying centuries of federal precedent make clear that states may not impede or interfere with the actions of federal executive officials when they're carrying out their laws. So when they're doing their jobs, you can't interfere. Why could this be a problem? What happens if we have a bunch of big Fanis who decide that they're going to use their offices to impede a political candidate that they don't like? Oh, is that happening right now? We've got Big Fani and Alvin Bragg doing the same thing. We've got Jack Smith doing the same thing on 2 federal cases. So the states can't act like little dogs nipping at your heels when you're trying to govern the federal government. In this case, a federal official carrying out his duties is not obliged to consider state criminal law at all before acting. They reference another opinion from Yale. Federal courts enforce these fundamental constitutional principles by granting immunity in state prosecutions and dismissing charges under Rule 12b. They say, Mr. Meadows removed this proceeding from Fulton County, Georgia, and he's writing as though he's already done this. We have not had a hearing on this removal yet. This is still pending. I believe the removal is scheduled to happen a week from today, I think on the 28th. But he's saying, I've already removed it. I've already invoked the power to do this, and it's done. The day after I was indicted, I filed it. Now, the court declined to send this back to the state level, which means that we're going to have a hearing on this. And they say, also, Judge, while you're considering this request, we submit a motion to dismiss. Why? Meadows is entitled to removal and immunity. The court can decide to permit removal and notify the state court, which will stop further state proceedings, and then address this motion on a more traditional schedule. They say stopping the state's criminal proceedings promptly is important. Both the Supremacy Clause and U.S. Code in Section 1442 protect federal officials from lawsuits and criminal charges in state court not just from liability. The suit itself, not just the result of the suit. But as set forth below, the basis for granting immunity to Mr. Meadows is well settled. The court should therefore move swiftly on both removal and immunity. They warned the judge, notice the judge. Your Honor, it's clear. Big Fani is seeking to move quickly in the state court so that Mr. Meadows will irreparably lose his constitutional and statutory protection if you don't do this quickly. Since 1890, since a decision in Nagel, the Supremacy Clause has been understood to stop states from bringing suits under state laws against federal officials. A federal official, including a former federal official, is immune when the charged conduct has some nexus with furthering federal policy. So if Mark Meadows is the chief of staff and he is investigating election fraud at the behest of the chief executive of the entire country, which is called the president at the time, who still has an obligation to make sure we have fair and free elections, is that a nexus? I would say so. Can reasonably be characterized as complying with the full range of federal law. Obvious analysis. As chief of staff to Trump and leader of the office of the president, Mr. Meadows served a critically important function, something that's been firmly entrenched for 100 years. The charged conduct here has far more than, quote, some nexus to his official duties. It involves literally the core aspects of the role. That's why he's in this role, to go execute the president's will. And while Meadows' conduct is alleged to have violated state law, it can reasonably be characterized as complying with the full range of federal law. So Big Fani can say, yeah, maybe it violates her state. That's her interpretation. But we're already in accord with the federal law. And that's what matters for Supremacy Clause immunity. Neither Georgia in its indictment nor the United States in its recently charged case has accused Meadows of violating federal law. Nobody's saying he's done that. But they are saying that about Trump. Okay, so now we see something that we can distinguish Trump with. So neither Georgia here nor in another case, which is United States versus Trump, where Meadows has not been charged, that's the federal case. Nobody's charging him of federal law, violating federal law. They are for Trump. So that means that the motion to dismiss, this exact motion to dismiss, you cannot copy and paste this for Trump. You got to delete that sentence. Even if they had, moreover, a federal official does not lose the Supremacy Clause immunity based on the violation of the law where the violation was not clear and willful. So it's got to be more. They have kind of a little bit of immunity built in. It's got to be clear and willful, kind of like qualified immunity, but maybe to a lesser degree. Mr. Meadows is thus entitled to have the charges against him dismissed. He can raise the defense now. And that is exactly what he is doing. So they give us a little bit of background here. They say the Supremacy Clause of the federal Constitution provides the following. We love our federal Constitution here. It says the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary, notwithstanding. In an interpretation from a Livingston case, they say, although the Supremacy Clause explicitly refers only to the Constitution and laws, its implication is that states may not impede federal officials when they're carrying out their laws. Otherwise, they could just bind somebody up in state court, just file criminal charges like they're doing, and stop them from doing anything else. Consistent with that understanding, the Supreme Court has long interpreted the Supremacy Clause to provide federal officials immunity from suit involving state charges to protect federal operations from the chilling effect of state prosecutions. It's not necessary for Congress to provide expressly for that immunity when we already have the Supremacy Clause. And it's implied by several acts, and we'll fast forward. Under our Constitution, they say states can neither enact nor enforce laws that retard, impede, burden, or in any manner control federal officers in their duties. And what they cannot do expressly, regulate the enforcement of laws entrusted to the discretion of the federal government, they cannot do indirectly through ad hoc enforcement of their criminal law. So just like Big Fani couldn't pass some legislation or do something that would supersede the federal courts, she can't use what she does have to supersede what the feds are doing. So she can't reconfigure the criminal code to be useful in an effort to impede a federal official who is lawfully complying with federal law. Saying these principles were well settled when the Supreme Court decided that case back in 1890. There, we had a different situation. There was a U.S. deputy marshal named David Nagel. He was charged with murder in California for fatally shooting a man while protecting Supreme Court justice. After recounting the colorful facts of the case, the court assessed that whether the Constitution and the laws provided a basis from freeing Nagel from state custody. So he shoots somebody protecting a judge. The state charges him. The court first ascertained that Nagel was acting under color of law because he was protecting the justice, and he rejected California's argument. The court said, well, we've got immunity here. The court said he did no more than what was necessary and proper for him to do. And they said that they can reasonably extend that under the law. Since Nagel, the Supreme Court has addressed Supremacy Clause immunity only rarely, hasn't come up much. Two most notable decisions came within 20 years of Nagel. In Ohio versus Thomas, in the Supreme Court case, we had another one, this one from 1899. The court held that Ohio could not prosecute a federal official for serving margarine in a home of a disabled veteran without placing a sign in the window. The court held that Congress had appropriated money to buy the margarine and that serving it was therefore legal under the Supremacy Clause. All right, so we've got a margin case here. We had another case, 1906. The court affirmed the denial of immunity for soldiers when they were prosecuted for murder. So they're soldiers, right? Now we're distinguishing what category of people, soldiers versus federal officials. There was conflicting testimony about whether the fatal shots were fired in hot pursuit. The court held that pretrial immunity was unavailable based on the facts of the case. Now here, under Nagel, a federal official is entitled to immunity if he was authorized to do what he did under the laws. At the general level, the question turns on whether the officers act have some nexus of furthering federal policy. While the phrase no more than necessary might suggest a narrow scope, so did Mark Meadows exceed the scope of his authority, they unanimously agree that immunity turns on the official's general role and the authority. The 11th Circuit simplified a lot of this. They said that the Supremacy Clause bars state law liability where the federal officials act, so Meadows or Trump's, have some nexus with furthering policy that complies with a full range of federal law. Once a federal officer, like Meadows or Trump, makes a prima facie showing, meaning just on its face, they say, yeah, we've got immunity, then the burden shifts over to the state, which is great. So you say, look, I can show that I'm a federal official. I can show that I was doing this in furtherance of protecting elections. And once I meet that burden, it goes back to you guys, Big Fani, to show why that is not true. Therefore, the district court should sustain the defense of immunity under the Supremacy Clause. Here's some of the argument. They say that Meadows carried out the conduct of chief of staff. That's what creates that nexus. And we got a lot of citations here, a lot of, looks like, law reviews. In a century, a lot more citations. They say here, okay, the conduct charged here by Mark Meadows falls squarely within the scope of his duties as chief of staff. And there's federal policy that underlines his role, and they're going to give us a list of it. He needs to show only some nexus, but here it's much closer than that. It's like his job description. This court succinctly summarized the charges in its own summary. They said that Mark Meadows met with Michigan officials to talk about the election. He messaged representatives from Pennsylvania to talk about a special session. He met with somebody to talk about, quote, disrupting and delaying the joint session relating to counting votes. He attempted to and was prohibited from physically observing a non-public audit, the Georgia audit. He arranged a phone call between Trump and a chief investigator. And he messaged somebody called Investigator Watson, and he solicited a phone call or asked the Secretary of State to do something, right? So they say, Meadows' team say, Your Honor, taking these allegations is true for assessing immunity. There is obviously a clear nexus between what Meadows was doing and his role as chief of staff. The question is not whether Meadows was specifically authorized or required to do each act. Like, was he allowed to send that text message? Was he allowed to make that phone call? Was he allowed to show up to that location? But the question is whether they fall within the general scope of his duties, and they surely do, they say. As noted, those duties included information gathering, providing close and confidential advice to Trump. And the way that the state characterizes any of this is wholly irrelevant. These were his duties. They were core functions of anybody who's a chief of staff. This is what they do. They attend Oval Office meetings. They contact state officials. They visit state buildings. They set up phone calls. They have a plain connection to all of this and the White House. So the nexus here is readily apparent. Only by virtue of his role as chief of staff was he involved in the conduct. If he was not chief of staff, he wouldn't have been involved in any of this. His federal position was a but-for cause, meaning but for being the chief of staff, none of this would have happened to him. They say if Mr. Meadows had absented himself from Oval Office meetings or refused to arrange meetings or calls, he could no longer have been the chief of staff. So what the state is doing, Your Honor, is it's threatening this very important interest. How can a chief of staff do anything if they're going to be under threat of state interference? Even the most dedicated federal servant would be reluctant to do his job conscientiously if it could mean prison time. And that's why the Supremacy Clause exists. If Georgia and Big Fani could prosecute a chief of staff to the president based on a course of conduct that is simply arranging meetings with legislators, presumably from states too, they could prosecute him as well. The implications are staggering, and the prospect would hobble not just the chief of staff and their ability to carry out the role, but how the president functions generally. This is contrary to the law. We want a president who's nimble. We want effective advice, an effective assistant, and the Supremacy Clause does not permit this conflict. So in other contexts, they say, Congress and the federal courts have recognized the need to treat the president's advisors differently. They need candid communications. The law must provide elbow room so that they can go have these conversations. The president has discretion. We give them some room to operate. You're not looking over their shoulders every time saying, is this according to Big Fani's law? Am I allowed to do this? As the DOJ explained in the Obama administration in a non-Trump case, absent immunity for the president's closest advisors, if they don't have it, congressional committees could compel them to do all sorts of stuff. And so this prosecution is obviously a case of a nexus between his conduct and his job. Now, they're saying he's also in full compliance with federal law. He didn't violate anything. Nothing that he did was unreasonable. The whole point of carrying out his duties is to do all of this. He was contacting board of managers, and they don't allege that he violated federal law or the Constitution at all. In fact, they're saying, yeah, there's no evidence that they're even saying he violated federal crimes. Why? Because in Big Fani's indictment, they're only referencing Georgia codes, OCGA, Georgia statutes. And while there has been a recent federal indictment, this is going to distinguish him from Trump. Mr. Meadows is neither charged nor identified as a co-conspirator in the indictment. He's mentioned by title 4 times in connection in that case as the defendant's chief of staff, as the defendant's chief of staff, as the defendant's chief of staff 4 times. So they're saying, okay, so they know he's in here. They know his conduct is here. They know who Mark Meadows is. They've reviewed his conduct. They found that Trump's conduct is criminal, but not Mark Meadows. So nothing suggests that he violated federal law. So if Big Fani can't bring the charges in state levels, and the feds have already investigated him, presumably, and have found nothing wrong, case has got to go. The core principle behind the doctrine of the Supremacy Clause immunity is that federal law, not state law, must govern the conduct of federal officials in carrying out their duties. The states may not second guess or superintend that role. This matter provides a paradigmatic case for applying immunity. The U.S. Department of Justice brought charges related to the aftermath of 2020, including Georgia. They omitted Mr. Meadows, and while Fulton charged him with a very similar set of crimes. So even if a federal official does exceed his authority under federal law, that doesn't forfeit their Supremacy Clause immunity. And the Supreme Court, federal courts have consistently held that federal agents are immune from state law prosecution so long as they did not violate federal law, maliciously or with criminal intent. And even if the court were entitled to conclude that Meadows is not entitled to immunity, he's still protected otherwise. He's still got the First Amendment and the 14th Amendment, and he's going to raise those up later. The First Amendment has its fullest and most urgent application when we're talking about the running for political office, so he can say and do things. And they say here, whatever one thinks about his phone call with the Georgia Secretary of State, it's a phone call. And he's allowed to vigorously and tirelessly represent and do his job. So Mr. Meadows, if you don't dismiss this on federal supremacy claims, we're going to make another claim under the 14th Amendment Due Process Clause and First Amendment because they are criminalizing conduct, and the statutes that are currently in place are unconstitutionally vague. Man, so they're throwing everything at this. So it's also a notice problem. So if you're going to now say that what Mark Meadows is doing is a crime, well, that's news to me, and that's news to every single chief of staff that's going to come down the line, because this all used to be normal, allowable conduct. Now it's not. So the laws are unconstitutionally vague for not giving me proper notice of what is illegal. And that's why these charges should be dismissed, because they're unconstitutionally applied. If Georgia law really does apply to Mr. Meadows, then it violates his rights under the Constitution. Accordingly, the court should dismiss all charges against Mr. Meadows in the indictment. Signed, sincerely, your friends, George Terwilliger. Good motion here. And these guys are moving quickly, my friends, moving very quickly. 30 out of 34 pages. We've already got a motion to dismiss. All right. So Fani filed those charges like, I don't know, 2 weeks ago? Like nothing. And we're already making motions in federal court for federal removal and a motion to dismiss. Now, there's some things to distinguish here, because Trump obviously has a parallel case, and they are prosecuting him out of the January 6 cases out of D.C. And we'll see if that causes the arguments to be different from Trump and his team, which I'm sure it will. But there's another component to this, because Meadows may also be charged. Some people are thinking maybe he gets charged in January 6 case in some superseding indictment or something like that. And he also might be a key witness in the documents case. So ABC News is reporting, and they had, I think, an exclusive on this, that the special counsel, Jack Smith, interviewed Mark Meadows, and Meadows told him that he doesn't have any knowledge that Trump ordered him to declassify the documents. So they're very excited about this. But they say, appearing to contradict Trump's claims, former Chief of Staff Mark Meadows told Jack Smith that he could not recall Trump ever ordering or even discussing declassifying a broad set of materials, nor was he aware of, quote, any standing order from Trump authorizing the automatic declassification of the materials, according to ABC News. So we're asking ourselves, right, who are the witnesses going to be? What does the evidence look like? The Georgia case looks like it is, weaker by the day, especially if the whole case gets removed to federal court. I mean, Big Fani is going to lose just by jurisdiction alone, and we'll see how she takes that. But we've also got questions about the Florida case. And so Mike Pence, who also has a classified documents problem of his own, is now brought in to ask, hey, Mr. Pence, do you know, did Trump declassify anything?
Joining us now is former Vice President and current presidential candidate Mike Pence. Mr. Vice President, thank you for joining us. I want to start with our new reporting.
Thank you, John.
I want to start with our new reporting about Mark Meadows. As you know, Donald Trump has claimed that all those documents he took with him to Mar-a-Lago, he had declassified. But we are learning that Meadows has told investigators that he knew of no such broad declassification order from Donald Trump. What about you? Had you heard anything to suggest that the president had issued an order, even a standing order, declassifying documents like that?
Well, first off, the handling of classified materials is enormously serious in the life of
not
the
that
nation.
serious.
But I can't really comment on your reporting. But
Joe had him, Trump had him.
In my case, I was never made aware of any broad-based effort to declassify documents. There is a process that the White House goes through to declassify materials. I'm aware of that occurring on several occasions over the course of our 4 years, but I don't have any knowledge of any broad-based directive from the president, but that doesn't mean it didn't occur.
That's right.
It's not something that I ever heard about.
That's right. It doesn't mean that it didn't occur. And as we've made the argument here before, the act of moving the boxes is constructive decision-making. Trump just does things and stuff happens, right? That's how power works. So he makes a motion, he moves something, he takes action in one way, shape, or form, presses a button, doesn't matter, and everybody responds. So it's a very interesting motion, and we're starting to see some of these pieces come into play in a unique way. It'd be very curious if Big Fani's case got pulled up into the federal level, because then it would very much overlap with Jack Smith's case, which was a concern we had from the very beginning when people were even wondering, is Big Fani coordinating this at all with Jack Smith? And it turns out not. So you might start with 4 cases and then turn into like 3.5 cases, and then maybe really like 3 cases. And then if Alvin Bragg decides to defer his cases, right, that one's kind of stalled out, then we just have the federal cases. And so it's a very dynamic, very fluid situation. Of course, we're going to continue to cover it, my friends, as it unfolds, including the Meadows motions, and the government will be responding to this. We'll take a look at that. So thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one. All right. Yeah, Meadows looks a little bit fired up there, doesn't he? Like he's got some serious business. He's like, all right. That's why, that's kind of why I picked that one. All right. So now let's get into this. Hunter's lawyers threaten Daddy Biden's DOJ, and they really have some leverage against the DOJ, which is weirdly, strangely, the president, Joe Biden, who's supposed to be running the DOJ, because if the DOJ is investigating his son, then the son can say, well, I'll just go ahead and call my daddy as a witness. And then that really complicates the DOJ, who certainly doesn't want their boss to be called in as a witness on one of their cases. They'd kind of look pretty foolish about that if Daddy President had to be dragged in there for all of America to see. So we know the plea deal exploded apart, and there was a lot of animosity between Hunter's lawyers and the government. They feel like the government backed out when we all know that they were trying to scam through a plea deal before the judge busted them on it. But the lawyers are responding, and now they have dropped a treasure trove of documents in with the media explaining their side. This is Hunter's defense team just saying, hey, look at everything we've got here that shows what a mess this was. Politico has this big article. It is juicy, so we're going to go through it. But they say in talks with prosecutors, Hunter Biden's lawyers vowed to put the president on the stand. The president. And so, yeah, that brings in some leverage. You know, oftentimes you'll do that in a criminal case. You certainly don't want us to have to call that person in here, do you? I mean, you know what that person's going to say about you guys. So if we call that person in, it's going to be pretty bad for you. And it's going to look kind of dumb for your case and blah, blah, blah. Right? This is a common tactic. Who can you leverage to bring in? Very common. But most defendants can't call the president in. You know, we don't have that opportunity. So here's a behind the scenes look at how this all went down. Halloween 2022. Hunter Biden lawyer named Chris Clark, who we've seen here, didn't sound happy. 3 weeks earlier, news had already leaked that federal agents believed that they had enough evidence to charge his client Hunty with buying a gun as a drug user. Wow, that's it. The leak was illegal, the lawyer wrote. He says it's purely political and it probably violates the Constitution. And then he issued a warning. He said, if the DOJ charges the president's son, he says, you people over there, we're going to subpoena the president. Clark wrote a 32-page letter, sent that over to the Department of Justice, and then Clark leaked it to Politico to embarrass the DOJ, which is Hunter's daddy's agency that just gave them a plea deal. It's crazy. They said President Biden now unquestionably would be a fact witness for the defense in any criminal trial. Okay? For the defense. Biden's going to come and defend Hunter against his own DOJ. You understand how insane this is? The DOJ is prosecuting the son of their boss. And then the defense is going to call in the boss to defend the DOJ. Like, it's clearly a problem, which is why it's, you know, generally a good idea to not have presidents with crackhead money laundering international criminal syndicate operators as their kids who exploit American interest and values. Like, you don't want that to happen because it could cause this little problem, as you see. So, well, maybe next time we'll think about that. But anyways, so Clark wrote a 32-page letter reviewed by Politico. Yeah, maybe they should have prosecuted him before President Biden became the president. That's another theory too, right? Because the DOJ was on this one for a long time. But they delayed. So in fact, the DOJ actually set them up to make this argument. So you see how this works? These are like tripwires, and you can set them up for yourself. So that, well, I mean, if we hide and cover up for Hunter long enough, it will postpone it past the primaries. It will postpone it past the election. Then it'll postpone it, he gets in office. Then when he's in office, then we can use the fact that he's in office to justify not bringing the charges even further against him or Hunter. That letter that was now leaked to the media, along with other 300 pages of other unreported emails and documents that were exchanged between Hunter's legal team and prosecutors, sheds new light on the negotiations. The deal would have resolved the most pressing legal issues. Yeah, the gun charges and the failure to pay taxes. No. He had dramatically more criminality that was at play. The real benefit of the plea deal is this: immunity. It would have insulated him from further crimes, the more serious crimes that they were petrified about. The documents show how the deal collapsed, a sudden turnabout that occurred after Republicans bashed it and a judge raised questions about it. The collapse renewed the prospect that Biden will head to trial as his father ramps up his 2024 re-election bid. So we might have Trump trials and we might have Hunter trials, which of course will just be a lot of fun. The case has been defined by politics, including by their own lawyers. We know that a lot of senators have been involved. Clark's letter and other documents were shared with Politico by a person with knowledge of the communications between the DOJ and Biden's legal team. The documents provide a detailed, behind-the-scenes look at how the two sides came to the brink of a plea deal. But after a judge asked a few simple questions, it started to fray. Yeah, and Hunter kind of botched that too. He did not have a good poker face, and I don't think that he really understood what was going on. He should have just nodded and said, yes, I'll take this deal anyways, and just execute both of them, but they botched the whole thing. Now the prosecutor overseeing the probe has made a special counsel and says the case is headed to trial. Been made a special counsel, which is insane because it's the same prosecutor who people say is already corrupted and already botched the underlying deal. Like David Weiss already, all of this first paragraph, he wrote it. They screwed it up. So they're going to give him a raise? Hunter's lawyer declined to comment. DOJ declined to comment. But more about the trove of documents. Started spring 2022. Biden's obviously in office. Hunter's lawyers met with federal prosecutors to try to talk them out of charging Hunter. They had a 100-slide PowerPoint presentation. Man, that's what I'm talking about. Shout out to my defense attorneys out there and your PowerPoints. Only slight suggestion would be to mind map it, obviously. But I like PowerPoints too. I'm a PowerPoint guy also too. I like cards and slides as well. Yeah. So the very first slide brought up Trump's first impeachment. What? And his constant claims that Hunter was a criminal. Biden's saga has long been intertwined with Trump. So his lawyers are saying it's all about Trump. And the DOJ is like, yeah, we hate Trump. That's a great point. They're like, what meeting are we in? Are we in a Hunter meeting or a Trump meeting? I don't know, but I hate Trump. Do you hate Trump? Yeah, I hate Trump too. All right, cool. Anyways, how are you, Hunter? You want to go to lunch? 3 years earlier, Trump had withheld military aid from Ukraine while pressuring the president to falsely announce that the country was investigating Biden. This whole thing is so reverse. It's like they committed all the crimes. Trump goes in, says, can you look into those crimes? Then they blame Trump for asking Ukraine to look into the crimes. It's just incredible. Unbeknownst to Trump at the time, U.S. law enforcement officials had quietly started investigating Hunter in 2018. Probe came to public light late 2020, leading to broad speculation that the incoming president could be criminally charged for influence peddling or money laundering. But by April 2022, as his lawyers convened, they had just one big concern: taxes, and whether prosecutors were going to charge him for willfully failing to pay his taxes from 2014 to 2019. We'll have a clip later of Shapley who confirms, they just dragged their feet on this, and some of the outstanding amounts that were due in the amounts of $400,000 just went away. 400 grand of tax liability, gone. Charges related to anything else didn't seem remotely imminent. They say, speaking to lawyers from the DOJ tax division and Delaware, Biden's attorneys opened their argument with Trump. All right, I would love to see the PowerPoint slides here. In light of Trump's ceaseless demands for the investigation, they say, if you charge the younger Biden with tax crimes, listen, if you charge the younger Biden with tax crimes, it would be devastating to the reputation of the Justice Department. You see, this is important stuff. The Justice Department does want to be seen as a legitimate institution. That's why they come out there. Merrick Garland says the same garbage every time he's out. We speak through our filings. No, like honorable law, purveyors of the law, whatever. It's all just nonsense because they want you to think that they're legitimate and they're not partisan political hacks who are prosecuting their political opponents. Definitely don't want you to think that. So what they're saying is if you actually prosecute in this little divide by zero format where you got to bring in the president, it's going to crush your reputation. Now, we've said the same thing about all of these Trump prosecutions. Every time they file a Trump prosecution, it crushes their reputation. Okay. Half the country, whether regardless of what you believe about the actual charges against Trump, you might be somebody listening who says, well, maybe one's justified or not or whatever. Half the country disagrees with it. So if you say half the country disagrees with that, times two for two prosecutions, then you add in the J6 prosecutions, then you look at like the Bannon prosecutions, then you see the non-prosecutions that have happened for basically, Michael Sussman and that whole saga. You see the list goes on and on. Then you see the Hunter Biden deal come in. And you ask yourself this, it's the reputation is just I would imagine just being shattered every day. Now, they are willing to make those reputational sacrifices on certain affairs. So they will eat it when they have to go out and prosecute Trump. There's this idea that when you raise your voice at somebody, or if you are an employer and you have an employee and you start screaming at them, right? That is an expensive maneuver. It's a very expensive thing to do. If you're in a relationship with a significant other, right? You yell or something, like you lose your mind. That's an expensive maneuver. You took something that cost your reputation, cost your persona some kind of damage. Every time. So if you're going to do it, it better be worthwhile, right? Use that stuff strategically. If you're going to blow your gasket, make sure it's strategic. But here, every time the DOJ does that, it's just crushing their reputation. And they do think about it. So it was obviously this concern was convincing when Hunter's lawyers brought it to them. They said, yeah, you're right. It would hurt us. But when they turn around and they prosecute Trump, it's because they want that reputation. They said it would look like the department had acquiesced to Trump's political pressure. They obviously didn't do that. They turned around and prosecuted Trump. They noted that Trump had laid into Biden in his speech, saying, "Where's Hunter? Where's Hunter?" Because we have a double standard. Biden's lawyers argued that the political pressure was itself a compelling reason not to bring any charges. Don't charge him because of the political pressure to charge him. So think about that with Trump. The DOJ, as we're going to see, accepted this rationale for Hunter, but they rejected it for Trump. Everybody wanted Trump prosecuted. We had Joe and Karine telling us, along with Kamala, that this was the worst thing since the Civil War. A move that, if they charged Hunter, would be seen as caving to the pressure, would discredit the department in the public eye, especially if it was only going to be late taxes. So Biden's lawyers also burrowed into the minutia of his taxes. They said, well, these errors were miscommunications, and he was a drug addict, so whatever. In the summer of 2019, according to one of the slides, Biden got sober, started working to make amends with the IRS. That's good. Got to make your amends, step 9. But he faced an unusual complication. He was at the center of Trump's first impeachment. The slide deck cites an email from one of the Biden advisors. So it sounds like it's very political. It's like, wow, maybe you shouldn't prosecute somebody if this is such a political thing. You shouldn't mix criminal prosecutions with political prosecutions. Strange, right? They're making this argument. Now, I have a meeting tomorrow with impeachment lawyers for the day, Biden replied. It will have to wait until Tuesday. Later in 2022, the DOJ confirmed to Biden's lawyers, the defense, that their client could also face federal charges for a gun crime. In 2018, while he regularly used crack cocaine, the same drug that Joe Biden imprisoned thousands of people, many of them African Americans, by the way, under his crime bills, including in the 80s and 90s, had allegedly brought a gun and signed government paperwork promising, among other things, that he didn't use illegal drugs. Possessing a gun as a drug user is a felony, as is lying on a gun purchase form. It was a different problem for them. But Clark argued the same political pressure Hunter's defense attorney meant bringing the gun charges would be scandalous. He sent a letter to David Weiss, part of plea negotiations, defense attorney over to prosecutor, so-called, the U.S. attorney for Delaware overseeing everything. Weiss was appointed by Trump, but asked to stay on or allowed to stay on by Joe. And Garland lied to us and said, no, Weiss had full independence. He can do whatever he wants. But Clark argued in his letter, defense attorney to the prosecutor, he says, if you charge my client Hunter with a gun crime, public trust in the DOJ is going to be shattered. Clark continued. He said, Biden didn't use the purchased gun to commit a crime. He didn't buy another one. He didn't have any prior criminal record. So these are standard letters that you send. I've sent many of these letters, and one tactic is to throw the kitchen sink at everything. And as we saw, they go through the taxes. They say, hey, we've got this other case law. No drug users ever been charged in Delaware. And the relentless political pressure from the opponents of the current president are also involved, which is also very true in Trump's case. After all, Clark noted, federal law enforcement officials had known about the gun episode since 2018. Only politics explained why years later they were considering charges. It's outstanding. The document included color photos of two former heads of Trump's Justice Department, Matt Whitaker and Bill Barr, talking about the Biden business deals. and another one talking about gun charges, where they also had Republicans like Grassley. They also had the failed prosecution of Michael Sussman, which we covered at length here. They said, you guys prosecuted Sussman, and a D.C. jury acquitted him. And the jurors said, we have bigger things to worry about here. What are we even wasting our time here? This guy's on our team. While working for Hillary, Sussman had alerted the FBI had tried to sell a fake dossier called the Christopher Steele PP tape dossier to the FBI. He brought it in there, gave it to James Baker, said, James, Trump and Russia, urination. And then the whole thing was a giant scam and a hoax. Sussman obviously knew that. Everybody at the FBI knew that, and they used it to get FISA warrants anyways. Clark implied prosecutors were risking the same sort of embarrassment. You guys wouldn't want to lose another case again, would you? Latham and Watkins, the firm representing Hunter, also represented Sussman. On top of that, Hunter's defense also said, the federal statute that bars drug users from possessing guns is constitutionally dubious at best, which I love. Yeah, it is unconstitutional, I'm sure. So, violation of the Second Amendment. Second Amendment advocates back in the House. Hunter's lawyers advocating for the Second Amendment. Clark also laid out what could have been seen as a promise, a warning, or some very zealous lawyering. He said, you better be careful here, government. Joe Biden would undoubtedly be a witness at trial because of leaks about the probe. He wrote that just a few weeks before sending his letter, there had been 2 back-to-back leaks about Hunter. A few days later, the Daily Mail got one, Washington Post got one. He says there's no doubt that these leaks have inserted Biden, president, into this case. He said, in this nearly unthinkable scenario, he's warning the prosecutors, President Biden would be able to testify to undermine a criminal case brought by prosecutors representing the United States of America. So it's dividing by zero. It's a massive conflict. It is a situation that is obviously problematic. It's just as problematic as one current sitting president prosecuting his chief political opponent in America, right? We have constitutional conflicts that are concerning. And Hunter's team even agrees. They say, making a deal from the fall of 2022 until the spring, Clark sought meetings with people at the highest level of the DOJ, almost entirely without success, almost. Multiple emails, he asked to meet with the head of the criminal division, tax division, office of legal counsel, solicitor general, attorney general Lisa Monaco. Oh, because he knows who really runs the show over there. And he tried to meet with Merrick Garland himself. Amazing. Clark's team reached out to multiple offices at Maine Justice, who just passed the request around. The search ended when Clark sent Associate Deputy Attorney General an exasperated email. This guy's name is Bradley Weinsheimer. Says he had asked the government over and over to tell him at the headquarters who to appeal to if Weiss decided to charge their client. He says, to date, we haven't heard anything. Please advise whether you would be the appropriate person to hear our client's appeal in the event that they decide to charge Hunter. Weinsheimer was indeed the right guy. He went and met with Clark and Weiss. Now, it's not clear what happened at the meeting. Of course not. Of course not. Which came at a sensitive moment for the probe. A few days before that, the Wall Street Journal reported that an IRS supervisor, Gary Shapley, was ready to tell Congress that political calculations were infecting the investigation. But unlike Biden's lawyers, who argued their case was being treated too harshly because of politics, the supervisor would say no, not such. In fact, he was getting preferential treatment because the DOJ was run by his father's appointees. We know that Weinsheimer from the DOJ on May 11th thanked Clark for the meeting and told him Weiss would handle the next steps. Thanked Clark for the meeting and says Weiss will take it from here. So Clark, Hunter's lawyer, is going to the DOJ. Hey, Mayor, you there? No. Hey, Lisa, you there? No. Hey, this person. Nope, all the way down. Finally, it gets passed around this guy. They're like, okay, give it to Weinsheimer. He has the meeting. Clark convinces him to do something, says Weiss will take it from here. Weiss will handle the next steps. The prosecutors appear to be nearing the end of their investigation and they're ready to make a deal. This type of process is not unusual where there's a lot of negotiations, and that is true. What is unusual is the president. On May 18th, another lawyer for Biden sent 2 Delaware prosecutors, including Leslie Wolf, a senior prosecutor there, the first draft of a proposed deal, structured so that it wouldn't need a judge's sign-off and wouldn't require a guilty plea from Biden. Oh my gosh. Oh my gosh. So why there are not, why Leslie Wolf is not being demanded to be dragged in front of Congress, I have no idea. A senior prosecutor, maybe she's on, I'm sure she's on the list, but I haven't seen anything from Comer. This is insane. The first draft of a proposed plea deal that wouldn't even need to go in front of a judge, which means it's not really a plea deal, it's kind of like a diversion, and wouldn't even require a guilty plea. Okay, so it's not a plea deal at all. It's like a total diversion offer. As part of the deal, Biden would admit he was late filing his taxes for 17 and 18, also say he owed a gun. He'd promised to pay any taxes he still owed, pay his taxes for the next 5 years, okay, follow the law, and never own a gun again. The deal would be made public, also cover 3 corporate entities affiliated with him. If he upheld the end of the bargain, they're not even going to, nothing, no convictions at all. Everything goes away. If he upheld his end of the bargain through January 2025, does that date mean anything? That's when the president's office changes. Right? Yes. So January 21st, I think, would be the day. The Justice Department would promise not to prosecute him for anything they'd investigated thus far, right? So he's immune for everything up until January 2025. So if Trump wins and his DOJ comes in, they can start investigating him. But anything that the DOJ had already looked into, basically all of those case files are closed, right? They're done. So you can't reopen those. If Hunter does a new crime, you can open those up. But if it's an old crime, like your Trump people are done. Those files are marked, concluded, immune. The DOJ would promise not to prosecute him for anything thus far. The draft wording of that promise was clear and broad, they say. And I'd love to see these documents. I hope that Politico or somebody publishes these, man. The DOJ agrees not to criminally prosecute Robert and the affiliated businesses, namely the following: Owasco PC, Owasco LLC, Scanatilalis LLC, for any crimes arising from the conduct generally described in the statement of facts. So they're like, Hunter was a crackhead and anything that he did from these years is now immune. For any federal crimes related to matters investigated by the United States. Weiss's team of prosecutors seemed pleased. Of course they did. Are you kidding? That evening, Leslie Wolf, the same person from my friends, these are government prosecutors, okay? I hope and pray that you never have to go deal with prosecutors in your life, that you are never in a situation where you have to deal with them. But this is not how it works, right? If you have a son or daughter or anybody who gets in trouble, this is not how it works. You say, hey, it's my son's first offense. He's never done anything like this before. He's 21. He's 19. They say, well, maybe he shouldn't have done that thing. How about that? Get out of my closet. And then the next person comes in. So this is very, very nice. The DOJ would insist on filing a court document charging Biden with 2 tax misdemeanors and 1 felony offense for possessing a gun. So they'd file the information. They'd want the deal to be structured as a pretrial diversion agreement, which one half of this already was, which means it would come with a built-in promise to drop all the charges against Biden, all of them, right? All, if he abided by the terms for several years. They'd want probation to supervise during that period. The deal would be public, and it would reference his drug use and sobriety. He'd need to stop using drugs and consent to drug testing. The deal would have also include a longer statement of facts, a lifetime gun ban, and a commitment not to publicly proclaim his innocence. Pleading guilty was not on Wolf's list of must-haves. No, of course not. Yeah, because she's concocting a deal. The government prosecutor who's on the team leading the investigation is concocting the most insane deal you've ever seen. The next morning on May 19th, Wolf pointed to another deal that Biden's could be modeled on. She says, oh, how about another one? We have another comparison case. There was a camera company called Aegis Electronic Group, 2011. They pled guilty. They didn't plead guilty, and the DOJ eventually withdrew the charges. Weiss had green-lighted that one because they were cooperating with the feds. So they actually got something for that. Okay, so in this case, the camera company was helping the feds get something. So they're like, we'll give you a good deal, but, and that does happen. Like, you'll see a deal like that, you know, like give 3 and go free is kind of a thing. It's like, you know, give 3, go free. And it's a situation where if the government has justification for extending a deal, like I won't talk unless, well, then maybe you see why the negotiation is justified. But this is not that. Biden's deal wouldn't need a similar cooperation agreement, right? He's not telling us what happened in Ukraine or what happened with CEFC or what happened in Romania. Who are these people? What are they doing? Nothing. He's just done. Doesn't pay the taxes on it, doesn't get charged, has blanket immunity. That evening, one of Biden's lawyers sent another draft pretrial diversion agreement addressing both the gun and the tax issues. It was still quite similar to their first. It also incorporated Wolf's must-have, which is the government, and it guaranteed Biden the same broad protection from prosecution for anything the DOJ had investigated to that point. It also guaranteed that the DOJ would move to dismiss all charges without any guilty plea. Not even a guilty plea. So, my friends, it was as bad as it was when we saw it the first time, when this judge asked a couple questions and derailed the whole thing. They wanted it to be even worse. 5 days later, on May 24th, Gary Shapley, IRS investigator, who had supervised the Biden probe and whose congressional outreach sparked the Wall Street Journal story, went public in an interview with CBS News. He says the DOJ is totally corrupted and slow-walked this investigation. Weiss and Garland have both publicly defended the integrity of the investigation, and we disagree with their characterization of that. Within days of the interview airing, the Justice Department prosecutors made clear to Biden's lawyers that the deal would have to change. Why? Why would the deal have to change? Oh, because they got caught. Oh. Gary Shapley and the IRS whistleblowers and their team saved this whole deal. They prevented it from happening. Their public pressure shined a spotlight down enough that the DOJ said we can't scam this through anymore. And so, shout out to the whistleblowers, my friends. Shout out and cheers to Gary Shapley and the whistleblowers. Biden would need to plead guilty to tax charges after they got exposed. Suddenly the deal changes, according to two people familiar with the talks who were granted anonymity to share sensitive details. Biden's team acceded to the new demand. They said, all right, fine. I mean, look, you're giving us everything we want anyways. So agreeing he would plead guilty to 2 misdemeanor counts, who cares, and willfully failing to pay taxes, but not pleading to the gun charge, and a diversion agreement would now come out. So the whole deal changes. On June 2nd, Clark emailed Wolf to tell her protection and immunity was vital. He sent sample language saying the United States would not prosecute Biden for any federal crimes arising from the conduct generally described. And it would be part of the deal. Now, I can't even imagine how frustrated they are at this point, okay, including Leslie Wolf. These people had been working on this for years. They had this thing buttoned up. They were going to cram this down our gullets. And these pesky whistleblowers stood up and exposed them. And he had 100 slides prepared. For what? Now this whole deal's off. So they reinsert the language. Its functional equivalent is very critical to us. And as we know, the broad immunity provision would give Hunter a layer of protection. If Trump wins and he ordered a wide investigation, nothing they can do about it because they're saying that is closed. Those cases are closed. Over the course of a few more emails, there's a back and forth on this. The lawyers on both sides kept line editing the deal. And on June 7th, Wolf sent Clark a version that included its final language shielding Biden from future charges. She said, all right, the United States agrees not to criminally prosecute Biden for anything in the statement of facts, and so on. The language refers to two different statement of facts, and we've spent a lot of time on this. There was a diversion deal and a plea deal, and they both had different paragraphs in there which reference the deal. Together, the two statements included a bunch of conduct, things like Ukrainian energy company, Chinese private equity funds, all of those were included. The language seemed to give Biden robust protection against the future charges, and the DOJ could only do something if he broke the deal. Obviously, he never would. But in court, when the judge started asking about the mechanics of how this all got concocted, a prosecutor said, yes, Your Honor, it is in fact unprecedented. We've never done anything like this before. Biden's lawyers would say, nope, happens all the time, but it didn't work out. The end was in sight, but Hunter's saga wouldn't stop. Prosecutors sent the deal to the judge on June 8th. She's going to oversee the proceedings. That happened to be the same day that Special Counsel Jack Smith charged Trump with other crimes at Mar-a-Lago. Isn't that amazing? So on June 8th, they send a deal to Hunter about Hunter that's going to totally immunize him from all crimes the same day that Trump gets charged. Perfect. Prosecutors had planned to file the documents on the Biden deal in court, which also happened to be the day that Trump was scheduled to be arraigned. Timing. Charge him the same day Trump gets charged. File the documents the same day he gets arraigned. All intentional. They are hiding Hunter's charges behind Trump's charges. The timeline got postponed by a week. It's not clear why, but the DOJ would have faced withering criticism if it had rolled out Biden's deal on the same day Trump was arraigned. On June 19th, Weiss's top deputy emailed Clark to tell him the U.S. Attorney's Office got a press call about the Biden situation. Oh, no. He says, let me run this statement by you, okay? David Weiss says, can I run this statement by you that I'm going to release to the public about Hunter? He was going to release it saying, it's my understanding the deal meant the investigation had concluded. The next morning, the deal went public. The DOJ said the investigation was still ongoing. The news created a seismic episode. Everybody called it a joke because it was a mockery of our legal system. Ron Johnson said it was a slap in the wrist. Experts even held mixed reviews. Republicans condemned this. We had our hero whistleblowers, Gary Shapley and Joseph Ziegler. They testified. The account contradicted sworn testimony by Garland. He said one thing. These two very credible people said another. They said the corrosion of ethical standards threaten our nation. Weiss defended himself. He says, I've been granted ultimate authority over this. He wrote in a letter, ultimate authority, including where, when, and whether to file charges. David Weiss wrote that in June 7th. He did not have that. He lied to us. He could not just on his own decide to file charges in D.C. or California. He had to go through the U.S. attorneys who were there. In D.C., it was Matthew Graves. Never had that ability. In Wilmington, DOJ officials were busy getting the sign-offs they needed to lock in the deal. they were all scrambling to just execute this. On the same day as Shapley and Ziegler's hearing, the top federal probation officer in Delaware sent lawyers a pretrial diversion report for fodder for a few additions to the deal. He said, okay, Biden's got to have a lifetime ban on ammo and let us know if you travel overseas. Okay. None of that created problems. They're like, we got to get this thing through before this, the wheels are coming off this vehicle. We've got to get it done. Sure, no problem. They added the recommendations, and a prosecutor emailed the revised deal to the judge's chambers, saying the prosecutors, the defense attorneys, and probation have all agreed. From the sound of the email, everyone seemed like they were on board. July 26, defense lawyers, scores of reporters, everybody gathered in Wilmington for the hearing in front of Judge Norica. It was an incredible breakdown. Virtually everyone expected Biden to plead guilty, as was called for by the deal, and for the judge to just stamp this thing off. But things went sideways. The judge asked how much protection Biden got. Leo Weiss, the prosecutor, said protection was narrow. Well, very narrow. He said under the terms of the deal, the DOJ could still hypothetically prosecute Biden for the illegal lobbying. He said that out loud, and they're like, wait, what? Clark says, no, you don't. That means you have no deal. And that the language in the agreement was more muscular than that. And the judge said, well, you guys better figure it out. All said and done, they couldn't come to a deal. In the following weeks, Biden's defense lawyers and prosecutors reopened their talks. Didn't go well. According to court documents, Biden's lawyers and prosecutors met shortly after the hearing, suggested changes, and the prosecutors are now having to cover up for themselves. Okay, they've got embarrassed on this thing. That's why Merrick Garland came out and appointed him to give him powers that he said that he already had. And now they've got to play hard now. The prosecutors didn't accept their proposals. And now the government has to be worried about the judge coming down on them, right? Like the judge also now knows there is no precedent for this. And the judge was asked to be involved in this as some sort of weird, almost like self-appointed judge to deal with breakdowns. Biden's lawyers rejected their suggestions. And according to a letter that Clark sent to the prosecutors, those prosecutors had proposed without explanation, completely deleting the immunity provision. And this defense lawyer is like, wait a minute, 2 weeks ago, you had it in here. What changed, guys? We all know what changed. They got caught. He says it was an abandonment of the language that they had painstakingly negotiated. It was a non-starter. He says it's unclear why the prosecutors, after weeks of negotiations, now want to narrow the immunity deal. He's a smart lawyer. He knows. Well, it's because they got caught. They can't make us all live with this deal now that we know about it. If they could have kept it under the rug and buried it under the Trump news, they would have done it. Besides that, Clark said the diversion agreement, including its immunity guarantee, were already locked in. He says, no, we already did it. We already signed it. In view of his lawyers, he says it's a binding contract, and they're going to hold tight to this. They're going to say the DOJ has already executed the diversion deal, and we didn't never even need the judge's approval for it. The DOJ responded, said, nope, sorry, it's not valid. Now they're really backpedaling. They say we need a probation officer, and we decline it, and therefore this might be litigated, right? So Hunter will absolutely litigate this. I would imagine at some point, I can envision us never reaching the issue right now. Like, we'll come to a conclusion that the DOJ is now in special counsel status, and they'll come to a conclusion about what all this means and what to do. And we might not actually ever get to a resolution from them. And then if somebody else charges Hunter, then he could invoke this deal. We'll see. The day after Clark sent his letter, David Weiss asked Merrick Garland to make him special counsel. Isn't that amazing? I thought he already had all the powers that he needed. Garland has long said that Weiss has total authority over the probe, including the power to bring charges anywhere, not just Delaware. But being special counsel would mean that he would get that authority in writing in a public document. Well, he already told us he had it. August 11th, Garland did that, walked out on a Friday, made the announcement, says Weiss filed papers to withdraw the tax charges so that they could file them elsewhere. Now that the parties are at an impasse, a trial is in order. So after 5 years of criminal investigation, slow-rolled, several weeks of plea deal talks, Biden is back where he started. And it is getting messier now because the DOJ has to protect themselves. They can't allow this thing to just continue on this same narrative because they got caught. Everybody can see exactly how corrupt they are. So this is Gary Shapley. We're familiar with him. He had a comment about the overdue taxes that have just evaporated.
When prosecutors don't allow you to put the subject's name on document requests or on search warrants, then it raises the possibility that there's more information out there we didn't find. But based on all of the financial records that we did find, they've been analyzed. It was around 8.3 million he received.
From who?
They came from China, from CEFC, came from Ukraine, and from Romania. And even the bereavement money, and it's kind of a aspect that we didn't get into, but the 2014 and 2015 tax years when the bereavement money was coming in. I mean, to this day, there's still around $400,000 of unreported income from Burisma in 2014. Hunter Biden was told by his partner Eric Schwerin that he needed to amend his returns, and he never did. So DC U.S. Attorney's Office declining those charges, David Weiss requesting special counsel authority and being denied, and then the statute of limitations then expires in November, December of 2022. So those years are gone. And there's no way to recoup the money from that Burisma income.
All by design. They just had this thing timelined out 1 year after the other, and they just executed it. So, of course, that's Gary Shapley. We're familiar with him. His lawyers over at on X, Tristan Levitt, and they create Empower US, which is a great organization that helps represent these guys. Put together a good thread. He says, all right, look, having read the Politico article and the New York Times stories that came out, the one that we just went through, he says, I've got several thoughts on these. And so make sure you're giving Tristan a follow. He says, first and foremost, it's shocking on its face that prosecutors were willing to let Hunter off scot-free. Piecing together these two stories with what we already know, even more alarm bells. He says a couple things. First, almost as soon as Delaware endorsed the conclusions in the 2022 memo, Hunter and his lawyers were already working with the referees behind the scenes. Okay, so in other words, Hunter and his team are talking with David Weiss and the actual people who are on the case, the people who are actually leading the investigation. But he's also going behind their backs, in other words, to the head of tax, to the head of DC, to the head of California, going to Merrick Garland, going to Lisa Monaco to go investigate all of them. The article doesn't reference the fact that the case had already been presented to Matthew Graves in March of 2022. Or that the same day Hunter's team was meeting with prosecutors, on April 26, Merrick Garland was on Capitol Hill saying that there will not be interference of any kind. But Hunter's lawyers were meeting with prosecutors from both Weiss's office and the DOJ tax. So Weiss is not the only decision point, right? They want to stop charges from coming. And so they want to get every single person up the chain of command. From the line prosecutors, they want to convince everybody, right? The investigators, they want to talk, if they could, they would talk to Shapley and, hey, what kind of flowers does your wife like? Yeah, well, how about I just send over some flowers tonight, because, or whatever, right? Because you want to convince everybody. Convince Leslie Wolf, convince David Weiss, convince this other guy, Scheimenheimer, the other Lisa Monaco, Merrick Garland, everybody. See if you can stop them, because maybe you lose at David Weiss, but you get some deviation at the next level, or you lose the next level, but Lisa Monaco steps in, right? And you don't just put all your eggs in one basket. So he's hitting them all up. If the DOJ had approved the charges, Weiss would have the full backing of the DOJ. But instead, the tax division granted discretion, which is why Weiss's team had to go hat in hand to the different venues. So he had to go talk to other people to do it. So the bureaucracy is impeding the proper presentation of this case by design. He says, presumably this awkward situation of not having the DOJ tax backing is why Weiss discussed special charging authority, because he didn't have his case endorsed by the same division that would bring the case. And he's not special counsel. So he said if it proved necessary, then he would follow the process. And now it's apparently necessary, right? But in addition to the conflict, Hunter's team was working all the refs and they made it all political. And of course, we know what happened then. They came up with a deal. Follow Tristan and read the rest of his beautiful thread to catch the rest of his analysis on it. But very good stuff from the whistleblowers. And we're just grateful that they came forward, because this whole thing would have just been steamrolled right through the courts if they had gotten their way. So now that it is being exposed, Joe Biden was asked about it. Joe, now that we're finding out just how corrupt your own Department of Justice is and what a scam they tried to create for your own son, what do you have to say about that?
And with regard to the second question, I have no comment on any investigation that's going on. That's up to the Justice Department, and that's all I have to say.
That's it. All right. It's up to the Justice Department, which is your department. You run the executive branch. You meet with Merrick Garland. Nada from him. All right. And one more from James Comer on this. He says, if the DOJ is investigating themselves and they're doing a terrible job investigating themselves, then maybe they are obstructing themselves. And what do we do in a situation where the people we rely on to bring us justice are the very ones that are undermining justice?
Even from people within the federal government, people that worked for him. And even more troubling than that, Maria, we've learned that when he was receiving emails pertaining to Ukraine, his son Hunter was copied on them, which we've always heard that the White House has said that Hunter Biden wasn't an employee of the government. He wasn't any part of the government. They couldn't understand why House Republicans on the Oversight Committee were investigating Joe Biden and his son Hunter Biden, because Hunter wasn't a part of the government. Well, if that were true, then why was he receiving emails from the government?
Well, this also pertains to the firing of the special prosecutor in Ukraine, Viktor Shokin. Was that what these emails were about? Because you have told us in the past that that was one decision you were looking at as far as a decision that Joe Biden may have been paid for to get involved in getting that prosecutor off the back of Burisma.
I think the evidence is mounting every day to prove that Joe Biden went to Ukraine for the sole purpose of firing Shokin, who was the Ukrainian prosecutor who was investigating his son for corruption. What we heard in the transcribed interview with Devin Archer was that he said that the owners of Burisma were squeezing Hunter, saying, we need help in Washington. You need to call Washington for help. Of course, the Democrats tried to say that, well, that could have been anybody in Washington. Well, what we've now learned is Joe Biden was using a fake email name to receive correspondence from his staff that he was copying Hunter Biden on. And I believe, Maria, that Hunter had to prove value to the Burisma owners that they were working on this. So he was forwarding those to the owners of Burisma. Look, this is obvious that Joe Biden abused his power as vice president for the sole purpose to protect his son, who was receiving millions and millions of dollars from this corrupt Ukrainian energy company. And this email ties Joe Biden and Hunter Biden into this corruption scheme without a shadow of a doubt.
Well, it also is quite interesting that Hunter Biden is even CC'd on any of these emails. This was government business, right?
This was 100% government business. Again, the Democrats in the White House have claimed that Hunter Biden and Joe Biden had a firewall between their business affairs. And again, Maria, as you know, there are no legitimate businesses here. The Biden family were receiving payments from bad people in bad countries around the world. And what we've been trying to do is figure out why. Why in the world would the Biden family receive over $20 million from foreign nationals around the world? And this is evidence to show that Joe Biden was communicating with his son. He was making sure that his son knew he was on his way to Ukraine. Remember, the timeline of these emails show that Joe Biden was en route from Washington to Ukraine for the sole purpose of withholding foreign aid to Ukraine in exchange for firing the prosecutor. And we know that happened. And we know Joe Biden accepted credit for it. He did an interview where he said, well, son of a B, they fired the prosecutor before I got on the plane and left Ukraine. Joe Biden in his own words said that. So now we have evidence that Joe Biden and his administration was communicating with Hunter Biden. They knew Hunter Biden was affiliated with Ukraine. That's another lie, Maria. Joe Biden said he didn't even know Hunter was on the Burisma board for a long time. This is another lie. They were copying Hunter, and the only emails we've seen where they were copying Hunter were pertaining to Ukraine at a critical time when Joe Biden was going there to fire the prosecutor in exchange for foreign aid. That's called a quid pro quo, Maria, and that's very illegal, and it's more evidence that Joe Biden was front and center in this influence peddling scheme.
Now, they're going to say that that's not enough. You know, they still want the check stubs from Burisma that say Vice President Joe. Only then, even then, they'd be like, well, yeah, but that was like a different consulting fee. There's an exception for that. But we can see that Biden's lawyers, Hunter Biden's lawyers, very aggressive with Daddy's DOJ, because why not? It's Daddy's DOJ. They can say whatever they want to him. What are they going to do? Not much. They can threaten and leverage the president into their case. We had a DOJ that was willful and willing to be complicit in creating this garbage deal. They tried to sneak it through under our noses. They got caught. And now they're trying to backpedal, to cover up and save what's left of their shattered reputation. The saga will continue, my friends. We're on the trial track now. We'll see where it goes as we continue to follow. Thank you for subscribing and joining us. As we do, we'll see you on the next one. All right. And we've got one final segment on the day. And this one is just amazing. Donald Trump already disqualified from 2024. That's it, my friends. Game's over. They did an analysis on this. There were some constitutional individuals, we'll say, like this guy, Judge Luttig. You may remember him from the scam, fake, illegally constituted garbage January 6th Select Committee hearings, so-called. And he was this guy that I think we listened to here live on this channel. That was one of the most painful, excruciating testimonies we've ever heard. Might be the reason we stopped listening to the January 6th Select Committee hearings in total, because it was so brutal and boring. And we're going to limit his time here on this segment today, but it is important that we listen to him, because both him and Lawrence Tribe are offering this new theory that Trump is already disqualified. And this theory is being adopted by people like Asa Hutchinson and Bill Cassidy and others, saying that Trump should not even be put on the ballots in the United States in 2024. Here is the judge.
It is perhaps the single most important conclusion that was drawn by the professors from their scholarship, namely that, as Professor Tribe said, the clause is automatic. It is self-executing, which means that, as Professor Tribe just explained, anyone, state or federal, who's charged with listing the candidates for the presidency is obligated under the Constitution to make the decision himself or herself as to whether Donald Trump is qualified to be put on the ballot under the Constitution of the United States.
All right, so just pausing there. Did you hear what he said? He says that the people who are in charge of determining whether somebody can go on a ballot, they are the people who will determine whether Donald Trump can be put on the ballot. They just get to make that decision. And we're talking about qualifications, right? There are other qualifications to be president. You got to be 35 years old, got to be a natural born citizen, and so on. You can't be on the ballot or become president if you don't meet those qualifiers. Just like, you know, in certain states, you can't get your driver's license until you're 15 and a half or whatever. Same thing here. They're just saying Trump is an insurrectionist, and therefore there's a self-executing feature of the Constitution that enables the people who make those decisions, who decide whether somebody's qualified or not, to just be the decider. So we don't have any due process where there's any formality where you get to go and be heard or have notice or anything. There's no presumption of innocence or an analog at all. It's just, on their own, people, according to these so-called law professors, that can change the election by keeping somebody off the ballot, right? These are the same hysterical lunatics on MSNBC who tell us that the right is constantly trying to steal elections, tried to insurrect America, tried to undermine American democracy. Okay. They're trying to keep people off the ballots by having secretaries of states just decide that on their own. And what we're seeing here, even if this is a boneheaded theory, there will be swaths of people who believe it, and it will set a pretext for maybe some efforts to gain momentum, right? The way this works is there's layers to this. Somebody will write a report. Christopher Steele will write a fake Steele PP tape dossier that everybody knows is fake. Everybody knows is boneheaded, means nothing. Then he'll take that, feed it to the FBI. FBI will also make some rumors they're investigating it, which means the media picks up on it. And then all of these people just confirm it until the fake PP tape is justified to get a FISA warrant to spy on the campaign. So it doesn't even matter if it's real or not. So that's what's happening here. They're planting the seeds, and we've already covered this story, made a video about this, I think a month ago, about the actual professors who were proffering this theory forward. So they plant the seed, then you start to onboard people onto it, some come up with some theory. Then this guy goes on MSNBC, and he's joined by Lawrence Tribe, some other big name lawyers who endorse it, and everybody on the left hyperventilated over this guy. He's like, he shed tears for Liz Cheney. Oh. And now he's got a whole new career as being an anti-Trumper, MSNBC contributor. You like how they parlay that, right? It's very, very convenient for them. And then they insurrect the country by keeping their political opponent off the ballots and scream at all of us that that's in the name of democracy. It's lunacy.
As to the role for Congress, frankly, until this scholarship by the two professors, I was not aware of the self-executing feature.
Yeah, because it's not real.
Of Section 3.
Yeah, you weren't aware
I'm
of
sure
it.
Professor Tribe was. He's written, thought and written about the disqualification clause his whole life. But this is of momentous significance itself, because neither Congress, nor Congress through impeachment, nor a judicial order, nor the results of a criminal conviction are needed as of this moment under the professor's reading of Section 3 and of my reading and Professor Tribe's. The former president is disqualified from holding the office of the presidency in 2024.
That's it, guys. Game over. Judge Luttig says a couple idiot law professors and Lawrence Tribe and this guy, they've come to the conclusion, Constitution says it, Trump should be removed, already disqualified. And this stuff is just planting the seeds, okay? These law professors, the people who came up with this theory months ago, they had already been sending letters. Now it caught stream in MSNBC, and guess what? Where else is it making its appearance? In the GOP presidential primary. Somebody called Asa latched onto this hook, line, and sinker. Now that this new theory has been embedded out there, he's ready to go.
But what I want to point out is I'm not even sure he's qualified to be the next president of the United States. And so you can't be asking us to support somebody that's not perhaps even qualified under our Constitution. And I'm referring to the 14th Amendment that a number of legal scholars said that he is disqualified because of his actions on January 6th.
Did you hear what he said? A number of legal scholars. There's like two plus Lawrence Tribe plus Judge Luttig, who until 5 minutes ago didn't even know there was a self-executing feature of the United States Constitution for disqualification. But then somebody was like, hey, got this new theory, Judge. We're going to disqualify Trump using this theory that didn't exist before. He's like, oh yeah, I forgot. I didn't read that line carefully. And then it burgeons, it bursts, and now it's in the GOP.
So what would you have officials in your state, any other state, do based on the 14th Amendment? Would you have them just leave Trump off the ballot, off the primary ballot, off the general election ballot?
No, there should be a court declaration, and so there would have to be a separate lawsuit that would be filed, in which there would be a finding that the former president engaged in insurrection, and that would disqualify him. That's one avenue.
They're going to do it. They're going to do it, my friends. They're going to start filing lawsuits. So just get ready for it. They're going to start trying to get him off the ballot in the various states, and it doesn't take many states. And if they can get him off the ballot in any state that's a big state that matters, you're going to hear the party screaming to pick a different candidate who can be on the ballot, because even if Trump loses one or two states in the Electoral College, if he's not even on the ballot, it's over. The game's over. So they're just going to say, pick a different candidate, and another candidate will be on all the ballots in all the states.
The other way would be that if a specific state made that determination on their own, then that would put the burden on someone else challenging that. Either way, it winds up in court for a specific finding. But I expect those lawsuits to be filed. I expect some states to take that action. But I think it's a serious jeopardy for Donald Trump under our Constitution not being qualified.
Yeah, it's a big problem for our democratic republic, our constitutional order. And they're going to wreck that in order to save it or something. So Asa is picking it up. And then this woman brought on this guy right after the fact, Senator Bill Cassidy. And he's also saying Trump should step down and step aside, stand back and stand by. And what's also curious, though, is he's going to vote for him anyways, which is a strange thing. So you'll figure out what's going on with this guy.
Former Attorney General Bill Barr says that the charges that have been brought against him are, quote unquote, responsible. Do you agree?
No, I don't.
Well, I'm not an attorney. There's 91 charges, I think. I think the charge that seems most likely,
they're illegitimate.
I mean, seems almost a slam dunk, is the one related to mishandling of classified documents.
Like Joe Biden and Mike Pence? Like those guys?
So I can't comment on the rest of them because apparently you have to prove state of mind. You'll have attorneys after me that can comment on that.
That's right.
But there's at least one, which is the mishandling of the federal documents, which is seems, again, a very strong case. They have a tape recording of him speaking of it. If that is proven, then we may have a candidate for president who has been convicted of a crime. I think Joe Biden needs to be replaced, but I don't think Americans will vote for someone who's been convicted.
They want him removed. Can we just vote? Can we just vote on it? Just let him run and let us vote, and we'll decide.
I'm just very sorry about how all this is playing out.
Do you think that Donald Trump should drop out of the race?
I think so, but obviously that's up to him. I mean, you're just asking me my opinion, but he will lose to Joe Biden if you look at the current polls. I'm a Republican.
I'm not sure that's true.
I think any Republican on that stage in Milwaukee will do a better job than Joe Biden, and so I want one of them to win. If former President Trump ends up getting the nomination but cannot win a general, that means we'll have 4 more years of policies which have led to very high inflation, to a loss of purchasing power for the average American equivalent to $10,000, and to many other things which I think have been deleterious to our country's future.
And it would be nice if the GOP actually helped with some of this stuff. You know, we've seen here and covered other stories where the Democrats have so-called charitable organizations that are out there raising tens of millions of dollars to register millions of people to vote. And they've got infrastructure for days. Meanwhile, the Republicans are here like this guy, just hemming and hawing about Trump. They've been doing the same thing for the last, 4 years, if not longer than that. Let's call it 7, screaming about it. Maybe if they would help create some infrastructure, rally around the chosen party leader that the party has decided by the voters, maybe we'd see a little bit more possibility of winning or fortifying the election against whatever the Democrats are going to do. But instead, we just get a bunch of naysayers that just, he's probably going to get indicted by a fake DOJ, get convicted, and then that illegitimate felony conviction is going to be enough to rattle Bill Cassidy that you shouldn't support somebody because a partisan DOJ created a fake felony charge against a political opponent. Who cares? It's an illegitimate felony. Doesn't care. Charge him with 1,000 of them. I don't care.
If Donald Trump does ultimately win the Republican nomination, will you vote for Joe Biden or the Democrat over the Republican on the ticket?
I'm going to vote for a Republican, but my threshold
So vote
issue
for
for
Trump
any
anyways.
person who wants to be the leader of our country is, will you take care of the issues before us? Both Biden and Trump both have the same policy on Social Security, for example, which is to do nothing. Unfortunately, Social Security is going insolvent in 8 to 9 years, which means that somebody watching this who's getting Social Security is going to get a 24% cut.
Well, that doesn't sound good. Shout out to our seniors out there. But all right, so this guy obviously is going to continue to vote for Republicans, even if it's Trump, even though Trump's bad and he should drop out of the race. So he's not going to support him. So then the Republicans are going to come back and they're going to say, see, we told you, you shouldn't have voted for Trump if something doesn't go our way. And we're all going to go, well, you idiots didn't jump on the board. You didn't jump on the train. You maybe could have been useful and you weren't. All right, we've got Adam Schiff, who says Donald Trump attacks our elections. And this is a surreal clip because almost every bit of conduct, as usual, that he describes here could easily be applicable to the Democrats and exactly what they do.
The problem, I think, writ large is when you attack our elections.
Like Hillary did, like you did.
When you say that the only way you lose is if it's rigged somehow.
Like Hillary did.
If you can discredit
like
our
Raskin
institutions
did.
to that degree, if you can attack the truth and fact sufficiently, then what is left to decide what our policies should be, who should govern? If we can't even agree on a basic set of facts, then what is left but violence to
Like
decide?
gender,
And
like
this is a hazardous
pronouns.
path our country's never been down. We need to stop the country from moving any further in this direction. I'm afraid that probably won't happen until Donald Trump is once again defeated at the polls. But it is a very disturbing trend.
Yeah, it's a disturbing trend, and it's always about stopping Trump. Everything's about stopping Trump. They don't care about anything else other than that. Here's Tom Cotton, senator, who is saying, a lot of this is really about politics, and he's right.
Not. Senate Democrats, and especially the Democrats in the Judiciary Committee, are like a phalanx of bodyguards surrounding the Biden administration. So
They do that. The Democrats rally around their candidate, and they rally around in defense of their guy. The Republicans do not. The Republicans just say, yeah, he should be disqualified. Maybe he should drop out. Maybe he should be imprisoned, like Asa and like the other guy.
haven't had so much as a briefing on the treatment of Hunter Biden with kid gloves, trying to give him immunity for every crime he ever committed in a way that a judge couldn't even review and sign off on it, versus the treatment of Donald Trump, where you now have 3 rogue, zealous prosecutors who are prosecuting Donald Trump for what's really activity involved in a campaign, core political activity at the heart of our democracy. Something that happened in 2016 and 2020, yet they're only now charging him in the summer of 2023. Why is that? It's because they want the trials to be in the middle of the campaign next year. They didn't bring these charges 2 years ago. They didn't bring them a year ago. They brought them in a way that would ensure that the media would obsess about Donald Trump's conduct in the past, not about what Joe Biden is doing in the present and what he will do in the future. Yet Senate Democrats have not even lifted a finger to examine this. And for that matter, the double standards you see on ordinary Americans. I mean, remember, we had the Department of Justice sicked on parents who are attending school board meetings in Virginia, worried about the propaganda and filth their kids were learning. We had a
Raw power from the left, from Biden, from the DOJ, and from these people. They do not want to even give Americans the choice about whether they can vote for Trump. Just pull him off the ballot. He's already been disqualified. Now we know that the GOPers are now talking about it. It's going to continue to go mainstream. There will be lawsuits filed. We'll see where it goes, my friends. Of course, we're going to continue to cover. Thank you for subscribing wherever it is you're watching this. Thank you for liking this video. Thank you for inviting somebody over to our channel so that they can join us as we cover this. We'll look forward to seeing you on the next one. All right. That, my friends, is it for us on the day. We covered some good ground on this lovely, lovely Monday. Trump already being disqualified. I guess that's it. I guess we should all just pick up, I don't know, checkers and gardening now. All right. We've got Hunter, who is threatening the Biden DOJ. We've got Trump and his chief of staff filing motions in federal court. A lot of good stuff happening out there. Now it is time to hear from you. Before we jump into your comments and your very appreciated super chats and support, want to remind you about our brand new website, robertgovea.com. It's still new. I don't know how long I can get away with saying that, but it's still new. robertgovea.com. Sign up anything if you saw in the mind maps today that you're looking for links, videos, PDFs. You can access it all, robertgovea.com. You can also become a member, watchingthewatchers.locals.com, and stick around for our members-only after party, which is where we're going to be going here in a short minute. I want to, last week, we had a couple comments that I missed. Last week, Tony Hay Munkett says, I was asking you to give a shout out to Rudy on YouTube. And Tony Hay, we accidentally deleted your comment. Apologies on that one. Or something. We did something to it. But yes, Rudy Giuliani has a YouTube channel, and Tony Hay was saying, let's give him a shout out because he is putting some good content out there. And so thank you, Tony Hay, for that one. We've got another one. This one came in from Bodie last week. Bodie said, I would love to see you interview or argue with a left Trump-hating lawyer like Brian Tyler Cohen, who I despise. Oh, well, I don't know who that is. With all due respect, I just don't know who that is. But, I've gotten a couple requests for that. I got a request for somebody else. I looked at them one time and I was like, oh, gosh. The idea of some of these conversations just sound painful. Some of them sound maybe interesting. I am working on more interviews and trying to develop that into our routine here. One thing that I always want to be cognizant of is I never deviate from this work that we do here right now at this time. I can never deviate from that, unless it's very, very intentional. But I have gotten requests for more interviews and stuff, and I think it would be fun to mix it up. So I'll keep that one in mind, and I'll check out Brian's work. Sounds like interesting work. Probably a sharp dude. We got this one from Dolphin Fan. Is the man bringing in 5 new members into our amazing YouTube members community? We got Designed Audios here. Dr. Dabs here. No Jabsky joined us. Teeny BB and Heather F. all coming in courtesy of Dolphin Fan is the man. Thank you very much, Dolphin, for bringing in those membos. We got Spuds says Kilo versus New London regarding eminent domain. I think I remember reading that one in law school. We were talking about eminent domain this morning and what a complicated topic it is, because you're like, I love property rights, but then there are some situations where it's complicated, right? It's a complicated one. So that's a good case. Kilo versus New London. Thanks, Spuds. The Most Banned Queen says, this is over on Rumble, says, I responded in comments on a replay of a members only video with a link to factual info on Hawaii fire victims who are still missing. Can I ask why my comment was deleted? Was it because we can't include links? So I didn't delete anything, the Most Banned Queen. If you would have commented on our Rumble channel, I would not have deleted anything, and I don't think it's anybody on our team on Rumble. Unless Rumble automatically deleted it because there was a link or something. It wouldn't have been us. We don't delete stuff in general. I mean, I very rarely delete anything. Unless it's like a threat. Unless it's like somebody threatening somebody, or if it's something, like pornographic or something, then that goes. But I almost never delete anything, even on YouTube. So I'm not sure what happened, but maybe try dropping it again. And I thank you for your support, the Most Banned Queen in the house. Sounds like good info. Rocky Water says, great stuff as always. Sorry I missed the morning show live. Starts the day off on the wrong foot. My comment, well, we missed you, Rocky. Glad you made it here, though, for the afternoon show. Says, my comment, I can't help but think the strategy all along was to get the Georgia case removed to federal court. I don't know why I say that, but that indictment, the only thing that makes sense with the way it was written was that she intended it to be removed. The contrarian in me wants the state court to judge this insanity. That's an interesting take there. Well, the state court would be more interesting because it would be more public, right? We'd be able to see that all. In federal court, it's going to be a lot more locked down. So we'd at least get some more eyeballs on it, which is always good. Honestly, Rocky, it's probably just stupidity and incompetence, if I'm being honest with you, okay? I just think that's it. Like, they wanted a big debut. They wanted to make a big splash. Stuff like this happens. Prosecutors will file charges with the wrong subsection and stuff like that. Like, it's nuts. But, and again, I don't necessarily think these cases are about getting outcomes per se. Like, they don't care about the convictions per se. The process is the penalty. So if they can just throw a big mushy just sack of grossness on this, that's mission accomplished as far as they're concerned. But Rocky, glad you made it. Thanks for swinging by. And hopefully we see you tomorrow in the morning as well. All right, so thank you to Rocky on that one. We had a couple others. S. McG says, if Garland doesn't get impeached, it's because Congress has no power. Republicans are cowards or scared people will realize how little power they have. The other thing I was thinking about this, S. McG, is whether or not the DOJ has leverage over the Republicans. Okay, I know how cynical that sounds, but I'm wondering, like, what do they have on McCarthy? What does the FBI and the DOJ have on McCarthy? Such that Monaco and Garland and Leslie Wolf are not getting indicted. What do they have? Who has the leverage? This should have already been done. Voice of the People says, if cases go federal, they can't be televised. All of this needs to be forced onto people so they can see how screwed our justice system is. Yeah, there's the point from Voice of the People. And so I think, Voice, you're saying we should be able to see it, which might be a benefit of why you want to keep it in Georgia. Although Adam Schiff is trying to get the federal courts to open these up. And I doubt that goes anywhere. But if Congress is asking, it's better than us asking. So thanks, Voice. Good to see you, my friend. Hope you're having a beautiful Monday. We got Melody says, regarding Biden testifying, that poor court reporter. Yeah, you're going to need a couple of court reporters, probably a translator, bowls of ice cream. And what if they call Karine in? Oh my gosh, what if they called Karine Jean-Pierre in? Like, hey, we got a question for you. She's like, well, I mean, obviously I have to defer that question over to the special counsel. No. Karine, you're in court. So did Hunter do this? Well, I can't comment on that. I have to give that to the Department of Justice. No, Karine, you're in court. You can't say that. All right, so it would be an interesting one. We'll look forward to it. A Bad Poet says, if Bribe-em Biden is typically away on vacation when things go down like Mar-a-Lago and other things, how did Joe know to go ahead of the Maui fires? It's a good question, too. And he, I think, flew to Maui today for like 4 hours and then flew back to his vacation in Tahoe. And I think in Tahoe, he's staying at some billionaire's house and he's not declaring who's paying for that either. So you want to talk about corruption, just look into that. We've got another one from God, hashtag then everything else for life. Says, which is a great name, God, hashtag then everything else, hashtag for life. Says, good to see you, my friend. Says, they want to be charged with treason for destroying the rule of law in the country. They all need to be charged with treason for destroying the rule of law in the country. We're taking the country down the toilet with all the lies and division. It's true about that. They are destroying the rule of law. And, treason's a good one, but I think, even obstruction, like they're charging Trump with obstruction. Something even, like treason's obviously a very charged charge, rightfully so. But even like simple obstruction, it's like, hey, you have a Department of Justice to run, and you're not running it. You're obstructing your oath. We've got Isaac Bowles says, I cannot believe that these people who rig elections are getting away with this. I can't believe people who rig elections are getting away with this. John McGarvey says, cheers to Shapley. Cheers to Shapley et al. And cheers to our whistleblowers. Whew, man, if they had not blown the whistle, this whole thing would have gone through. And we would have all woken up one day and Hunter's like floating around with a crack pipe again. Like, what are you guys going to do? Because he's got total immunity. Amazing. All right. Thank you, Rocky Water. We got this one for Goofy for Jesus, baby. Says, regarding the Georgia cases, leaked case about that number. Is that case number tossed? The real case is that number. What is the case, that one? Was this, quote, judge shopping? Love y'all. That's a good question. So I don't know the numbers off the top of my head, but I can just answer generally speaking. Sometimes depending on the court systems, and in Arizona, I've been to well over 100 Arizona courts in different appearances, and they do things differently, and oftentimes counties do things differently. So what we would have would be sometimes the charges would each have different numbers, or co-defendants would have different numbers. So it could be something like that, or you could have had a blank case that was that fill-in case that was later tossed. But I don't know that necessarily that means judge shopping. Like, I see, like, did they submit a case and then dismiss it because that case got assigned to a different judge and then refile it under a different number to try for a different judge? It's an interesting, I don't know, it's interesting. I wouldn't put it past them. I wouldn't put it past them. But that's curious, and I don't know the details. But thank you, Goofy for Jesus in the house. We got Glenn Croy. Thank you, Glenn. Says, Robs, towards you and the boys, popcorn. In movie, you bunch of lady slayers. That's right, baby. You know that, Glenn. You know it. Thank you, Glenn. So popcorn and movie night. We got movie night coming up, and that's going to be on September 2nd for our members. If you're a YouTube member or a Locals member, get your popcorn. We're watching V for Vendetta on our own. We might, highlight a couple clips here and there when we do it'll be a nighttime live stream, or nighttime-ish. We'll turn the lights off and have some popcorn and have a movie night and talk about how the movie relates to our current situation, and other things. It's going to be fun. We had one for Contact. It was a lot of fun. All right, Glenn, thank you so much for that. Appreciate you being here. SD1985 says, real question, how screwed is the DOJ? Well, I feel like they're flailing. I mean, I really feel like they're scrambling to try to protect their legitimacy, to protect their reputation. Every time they charge Trump or don't charge Biden, it's just one more blow to their reputation. And long term, I think that they're on a downward trajectory. People will have less faith in them, and they get in this doom loop, this downward spiral, because what they do when you're a government institution and you start losing power, the problem for them is that part of the reason they're losing legitimacy is because they're misappropriating their power. They're not using their power legally, lawfully. They have double standards. Nobody trusts them. Nobody believes them. So they're using the power they have inappropriately. So when that happens, the only tool they have to actually do anything about this, to try to repair their reputation, is their power. And oftentimes, the people who corrupted the power in the first place will continue to corrupt the power in the aftermath. So in order to fix themselves, they often will double down on the strategies that got them there in the first place. In this case, they're just going to indict Trump harder. All right. And that only accelerates the illegitimacy trap that they are caught in, and it undermines them even further. And so it's this snowball that just keeps rolling down the mountain, and they are doing it right now. I mean, we're watching it happen in slow motion. Randy's here, says, I appreciate you. Thank you, Randy, and I appreciate you right back. Thank you for that. Says, just started your watching a few weeks back and have found your videos to be greatly informative. First time sending a super chat. Thank you, Randy. Very, very generous. I appreciate it. And you say, please have a drink on me. God bless, and God bless you back. I'm glad you found the channel. Thank you for sticking around. Thanks for sending in a super chat. And I hope we see you joining us, because it's going to be wild times, man. We got wild times ahead. Thanks, Randy. I appreciate it. We got Waldo. Thank you, Waldo, for sending that one in. Also a member. Waldo's in the house. We got Kelly, says, all I got to say, we dodged the bullet with Merrick Garland as SCOTUS. Gosh, tell me about it. I don't know that Merrick Garland is much more than an empty vessel, honestly, like Joe. I haven't really heard much from him in terms of actual leadership. He just comes out and gives deliberate speeches and then probably goes back to bed. I don't know. We got Chef Tony Novak. First super chat from Chef Tony. Thank you, Chef. Says, even Dershowitz has now announced he would debate L Tribe on this anytime, anywhere. Creative interpretation of the 14th Amendment is complete rubbish. Yeah, this is like a new thing, I think, like self-executing disqualification things in the 14th Amendment. So that's great. Yeah, Dershowitz is probably highly qualified to have that debate. And that would be a fun one to watch. Look, Lawrence Tribe knows this is all nonsense. They all know it's nonsense. They just hate Trump so much. And they also, you know what else they also hate? Coincidentally, very conveniently, the Constitution. They hate the Constitution. And so they hate Trump too. And themselves. Yeah, so they hate everything. So they don't care. And they don't care if you hate them. They think that you're a bigot and your adherence to the Constitution and the original interpretation is irrelevant. And K Bean over on YouTube is issuing a very important warning, says, Chef, please stay away from former presidents. Be safe out there, wherever it is you're cooking. We got, thank you, Chef. Orion Starman says, Robert Barnes covered Section 3 of the 14th weeks ago. It doesn't apply to those running for president. Sounds like a good take. Well, according to them, they can just apply it to anybody they want, anytime they want, on their own, sua sponte. And if Trump wants to get back on the ballot, he's got to file a lawsuit. So you see how they're shifting the burden to him. We got John McGarvey sharing this one. Thanks, John, for clipping for us. 51K boss. 51K boss in the house says, just wondered when the last time you Googled yourself was searching for your logo and came across a gem. Oh, gosh. I don't know. It's been a long time. It's been a very long time. So I don't know, but I should do that. I should do that, actually. No doubt. And maybe I'll have to do that. Thanks for announcing that on the show for us all. We got Ray K says, I want a red hat logo on the side and stitching, please. So awesome, Ray K. We posted some good merchandise updates for our members on Locals and on YouTube. And there is a lot in the works. So we've got some very cool stuff that is about to be printed and stitched, and we're having some final refinements that are out there. And so I don't know that we'll be able to get a red, but we're working on it. We're working on colors. But thanks, Ray K. And it's a work in progress. So thanks for being here and joining us. We'll work on the red. John Tasadaka's here. Says, just want to remind you all about the Null brothers trial starting tomorrow. A couple more poor souls caught up in the Whitmer saga. There's a retrial for Whitmer tomorrow? Okay, thank you for that. Tasadaka in the house over on Locals. And then I think, yes, okay. Yes, that's coming up. Thank you to Sadaka. We've got this one from Barb's Loves Alaska on Rumble. Thank you and shout out to our Rumble friend. Says, do actions by states have to start before it can go to the Supreme Court on those states to try to remove President Trump from their tickets? Well, it's a good question. So I see what you're asking. Like, does Trump have to wait for them to do something to go and get a declaratory ruling on this? Not necessarily. I mean, he could go and petition to them. I don't know that the Supreme Court would grant certiorari on something that hasn't manifested itself quite yet. Like, they would say it's not ripe enough. It hasn't actually happened yet. But this is the same type of problem that we had in 2020 when they were changing a bunch of stuff. And they used COVID to change the rules. Now they'll use insurrection to change the rules. And if you try to fight back against it, then they'll say you don't have standing yet because it hasn't actually occurred yet. So I see a very similar thing happening again. Now, if a Secretary of State or if a governor or somebody intimated about this officially, I think that would give Trump some standing to then file for a declaratory statement on this. But if you file for a declaratory statement or you get clarity on this, you run the risk that maybe they say, yeah, they're fine. Maybe you can't be on the ballot in some states, right? I don't know. Complicated. Of course, this is exactly what they're going to try to do because they're cheaters and bullies and they can't play fair. Thanks, Barbs. The Most Banned Queen says, it was on YouTube. I posted it on the members only. Maybe I should email it to you. Yes. So links will not work on YouTube to my knowledge. So that's probably why. So yeah, email it to me. My email is best, robert@spotlightlawyer.com would be the best place to send it. And thank you, the Most Banned Queen. Yeah, I don't think YouTube will accept links at all. Allegan News says, didn't Judge Luttig also say you can detain U.S. citizens with no charges indefinitely in Gitmo? I don't know the details on that, Allegan, but it sounds like you probably do. And Yeah, it wouldn't surprise me at all. A lot of these people just make up whatever position they need to serve them at the current moment. At the current moment, he's an MSNBC contributor, and so that is very useful for him in that role. We got Red One says, oh, we've got a new, so follow the World Health Organization and do whatever they say. The U.S. is doing stuff again. Great. John McGarvey says, I thought I was the quintessential cynic, but brother, you're at the head of the list. The goods on the repubs in the House. Woo! Bad. Crash to contrary. Brother, you're at the head of the list. Yeah, I'm a defense attorney in my DNA, man. I'm skeptical and cynical, and I doubt everything. Everything. I can't help it. Probably not going to be changing either. What I do have to question myself, sometimes I wonder if I'm just too hyped, too spring-loaded sometimes. Like we were joking about this on Locals. Like when Merrick Garland came out and announced the special counsel for Hunter Biden, I flew off the rails. And I was thinking, you hardly even barely thought about that before you flew off the rails, like a spring-loaded jack-in-the-box. Barely. And I was wondering, like, well, what if he came out and delivered like an amazing, he's like, yeah, no, Joe Biden's a criminal and we're indicting him. And he's being arrested and arraigned right now, in fact, because we found everything. Like, what would my reaction be? I don't know. Would I still be like, ah, wait, what? I don't know. So you got to be cautious about that. Where are our blind spots? I know I've got them too. We've all got blind spots, even Jake Tapper. All right, Danny McWilliams on the X. We'll say hello to the X very quickly. Just give some shout outs. We got Danny McWilliams. We got Fred Pedamonte says Fani will call this the white supremacy clause. That's a good one. Danny McWilliams says he said it that he thought it, not as a judge. We got James Peppers there. Says last time the Democrats tried to eliminate a Republican, we had a civil war. Hopefully that doesn't happen again. We got Barbs. Says, man, I have notifications on, but we're not getting them. Sylvia says best legal analysis here. Thank you, Sylvia. Cajun Joey is talking about Gateway Pundit. Yes, so Trump's bond has been set at $200,000. Thank you for that. We're going to come back and hit that tomorrow. Oh, by the way, forgot to mention this. I should have mentioned this earlier. Tomorrow's show is going to be earlier, probably 11 my time, 2 p.m. Eastern time, I think is going to be the schedule tomorrow. I've got an afternoon thing I've got to attend to. So I forgot to mention that. So show will be early. I'll post a note about that tomorrow. We got TJ King, old drill sergeant. Spuds is in the house, says Rob's in regards to the eminent domain. Check out Kilo versus New City. And Pete and Rachel says, thanks, Robert. Your channel is required reading over here in the UK for people interested in justice. Very meaty reporting, sir. Thank you, Peter and Rachel. We try to keep the meat on the bones over here. That, my friends, is it for our friends over on the X. Shout out to the mods and the meme smiths on the day. Vienti Kiss Prime. We got K-Bean, Just Cause, Playing Hooky, Ronnie Cole, our friend Zulu, Beyond Geo. We got Zach Nichols, John Allen, Janek, Dog Digger, Donut Mind Me, John McGarvey, all in the house, along with our meme smith, Sleepy Dog Lee, Geegum Geegum, and Nathan N810 in the house. And we've got this one from 50K Boss said, not trying to change your logo, just thought a justice should be a lady and less of a reaper. That's a good logo. Yeah, that's a good one. I think that's a pretty nice design on it. Yeah, I think it looks pretty good. And we're constantly changing stuff. Now, see some of the like our lady justice is actually a lady, but we simplified it a little bit for the stitching. So like, let me share this with you while we're here. You probably couldn't see it in the stitching because we got rid of her face. And you'd probably have to do the same thing on this logo because the stitching just really can't get the details all that great. Where is the other one? But I do like this. I think it's a good one. Anyways, all right, it's not syncing up, but thank you for that. 51K Boss in the house. We'll do more deep dives on the logos and everything else we're working on. But that, my friends, is it for us on the day. We are going to leave it right there. Members, stick around. YouTube friends, we'll see you on Telegram. Navigate to the community tab. Join us on Telegram. Locals, we'll be back in 60 seconds, so stick around. My friends, that is it for us on this lovely, lovely Monday. We've got a fresh new week ahead, and so we'll be back here tomorrow to get into it all again. Early show, 2 p.m. Eastern time. I'll see you back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. See you right back here tomorrow. Bye-bye.